Make of the defense challenging Indigenous people during the jury selection, and does an all-white jury make this trial inherently unfair? Well, joining me now from Thunder Bay is Julian Falconer. He's a legal counsel to the Anishinaabe Nation. He advised a committee that is looking at increasing representation of First Nations people on juries in Ontario. Julian Falconer, you probably heard that clip from Colten Boushie's family, who said the deck was stacked against them. Is this an argument you hear often?
Certainly, but as a starting point, and you'll appreciate the large distances involved, but from Northern Ontario at the Anishinaabe Nation Chiefs and Assembly, which is going on as we speak, the Grand Chief of Nan, Grand Chief Alvin Fiddler, and the Chiefs want to express their condolences to the Boushie family, to the family of Colten Boushie, who obviously, in terms of their loss, there's no way to measure that. I think the concerns expressed are not just concerns expressed by members of Indigenous communities. They have to be concerns expressed by all of Canada, that you would have such a substantial population of Indigenous people within a jurisdiction, within a judicial boundary, but magically the jury would be an all-white jury. And you have to ask yourself the role of the justice system in making this happen, the role of peremptory challenges, the right, without any grounds at all, for a defense counsel who's doing their job to simply cleanse the jury of First Nations individuals. And it's not because someone is abusing their powers as a lawyer, it's because the rules actually permit this.
So what is the advice, as you look through this, what is the advice to try and ensure that there's a broader representation, particularly among Indigenous people, when jury trials are chosen?
Well, first of all, I think what may be missed in all of this is Saskatchewan happens to be the only jurisdiction where, when convening coroner's inquests that use juries, but not criminal trials, but convening coroner's inquests, the chief coroner actually has, under your legislation, has the right to actually ensure that members of certain cultural groups, or in this case Indigenous people, could serve on the jury conducting an inquest, because it's in the interests of justice to ensure that that appropriate representativeness is there. I only point that out to say the following. No one can think to themselves that in respect of this particular death of the young Mr. Boushie, in respect of his death, that there isn't an issue of race involved. You know, I read the words of the defense counsel that he wanted this not to be a referendum on racism. But obviously, this is injected with racial issues. And to see an all-white jury in this case does nothing but hurt the perceptions of the administration of justice. And really, there was much work being done towards changing that, towards creating a more representative system. And unfortunately, the Supreme Court of Canada, in a judgment in 2015 called Cacoponus, did not go the direction of supporting that work, but in fact, frankly, with all due respect to those judges, have really given the government a pass on ensuring that we have representative juries, because they held that it didn't go to the validity of the jury trials. And so we're back to square one. We have an extremely intransigent Ministry of the Attorney General from the Crown Law Office Division in Ontario. We have lack of pressure on the federal government to make changes. So sadly, I think this is going to continue. And what you have to ask yourself is, what has this done for justice? Mr. Stanley's absolutely deserves a fair trial. But how does it help justice when a family so stricken, as the Boushie family is, looks up and sees nothing but white faces in that jury panel? What does it do for the system?
I want to get to that in 1 second, but I know that a lot of the media reports are about how they looked at a panel selection, potential jurors that were 750 people, but a fraction of them showed up, in large part because the distance, the catchment area for this judicial area was huge. People would have to travel for hours. So is that part of the problem? And then we can get to the more substantive issue about justice itself.
You would think that geographic boundaries would account for it, that long distances travel would account for it. But our experience on this very issue in the last 10 years in remote northern communities was that when we went to Indigenous people in a respectful way, when we went to fly-in communities in a respectful way in something called Operation Invite, an actual jury, a volunteer jury project for coroner's inquests here in Ontario, that produced 473 volunteers from First Nations. Despite their distances, they were prepared to do it. when approached respectfully, not with an invitation from Her Majesty the Queen in the form of a summons, but with an offer to engage with our Indigenous brothers and sisters. So the short answer is, I don't think geography accounts for this. I think alienation from a justice system accounts for this. And what you're seeing transpire in this trial is doing nothing to help that.
All right. So there is a solution. You've given us a couple of examples of how that might happen. Talk about the will. Justice has to be seen to be done. You said in the Boushie's family case, clearly when they look at the jury, they will not feel that way. So what are the most practical and what steps need to be taken to address this?
First and foremost, the courts have to support the efforts of those looking for representative juries. The politicians are not going to react if the courts themselves, if the judges, the justice system does not push for it. So yes, we have an unsuccessful verdict in the Supreme Court of Canada, but I don't stop on that. I say that there's still more advocacy to be done. Secondly, you have intransigence within most of the sort of conventional prosecutorial arms of the ministries of the Attorney Generals, and certainly in Ontario that's the case. So what we need to see is pressure. We need to see pressure from the outside to insist that as a matter of reconciliation, that as a matter of understanding our obligations to our Indigenous brothers and sisters, that we actually make the effort to be inclusive. That means going a lot further than conventional tools would permit. But I want to point out one thing. This role of this tool called a peremptory challenge is completely suspect. That is, why is it necessary to give a lawyer 10 or 12 rights to exclude someone without any grounds whatsoever?
Okay.
We're not talking about excluding somebody for they may have showed a bias, they may have read information about the case. We're talking about the right to simply remove someone without an explanation.
Okay. Julian, I have to leave it there. I appreciate your time today. It's an important issue, and we'll be discussing it in the future. Thanks very much.